Hello?
Hello.
Yes, sir. Can you hear me, sir?
Yeah, this is Virgil Trahan.
Okay, everybody that's on Zoom, please put your mics on mute. When we call your case, you can take your mic off of mute.
So she's here.
Mr. Trahan, put your mic on mute.
I'm trying, sir.
Thank you. Okay, Jefferson County Court at Law number 2 is now in session. The person that's on Zoom is Virgil Trahan. Is that your full name? Oh, your mic is on mute. Turn your mic off of mute.
Virgil D. Trahan Jr. is my name, full name.
Okay, hold on a minute. Mr. Trahan,
Yes, sir.
you represented by James Paget.
Yes, sir.
We show that your court date is May 7th.
Okay. He just gave me this one and told me to be on by 9 this morning.
Okay, well, you need to call your attorney because we have you down for May 7th.
May 7th?
Yeah.
Okay.
All right.
Thank
Get in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
Thank you, sir.
You're welcome. The other person that's on Zoom that just has an iPhone, please take your mic off of mute and state your full name.
Justin Diaz.
Mr. Diaz, okay, you can put your mic back on mute. Thank you.
Thank you.
Mr. Morales, please put your mic on mute.
1 second, sir. I
Yeah, okay, wait, hold on a minute. Okay, don't worry about it. I'll mute it for you. Morales. Go ahead on and get him in. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, we have 2 dockets. We have our announcement docket and we have our motion to revoke probation docket. When I call your name, please come forward with your attorney. If your attorney is not here, then we will wait for your attorney to arrive. If you're not represented by an attorney, and when I call your name, please come to the bench by yourself. First case is cause number 24 CCCR 2790, case of style of the state of Texas versus Victor Morales.
Yes, sir.
Okay, Mr. Morales, how are you doing?
I'm good.
That's good. Now, Mr. Morales, you represented your case by your attorney, Attorney Jared Gilthorpe. Attorney Gilthorpe, how are you doing?
Good, well, good. How are you?
I'm doing fine. Thanks for asking. The state is representing this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
Great, Judge, thank you.
You're welcome. Mr. Gilthorpe, what is your announcement in Mr. Morales' case?
Judge, in Mr. Brown's case, discovery has been completed and we've also applied for pretrial diversion. And so we request time to get a response on pretrial diversion in this case.
Okay. And the next is June. So we're gonna set it the second week of June. Okay, this case will be reset to June 9th, 2025 at 9 a.m. Mr. Morales, your case is being reset to June 9th, 2025 at 9 a.m. On that date, You need to appear in court. Your attorney, Mr. Gilthorpe, and your bondsman will be given notice of your resets. You're free to go, and you have a blessed day. And Mr. Gilthorpe, you're free to go as well.
Thank you.
Thank you.
Victor, you can disconnect now.
Yes, sir. Thank you, sir.
Okay, thank you. Let me Think so. Yes. Okay, next case. Well, the next case is cause number 24 CCCR 2844, case of style of state of Texas versus Ivan Silva. Mr. Silva is appearing via Zoom. His attorney is Mr. James Paget, who is also appearing via Zoom. Mr. Silva, you can take your mic off of mute. How are you doing, Mr. Silva?
Pretty good. How about you?
I'm doing fine. Thanks for asking. And Mr. Silva, you're representing your case by your attorney, James Paget. Attorney Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. And Mr. Paget, what is your announcement in Mr. Silva's case?
Your Honor, we have received all the discovery. What I need to do now is hook up with Mr. Silva, and I'll contact him today to do that. If you could just give us a date where we could both appear in person, we
Okay,
can
give
take
us
care
a
of this
date.
case.
Okay, this case will be reset to May 23rd of 2025. Mr. Silva, on that day, you need to be in court in person. And Mr. Paget, your reset will be sent to you. And Mr. Silva, your attorney and your bondsman will be given notice of your recess. Stay in contact with your attorney and your bondsman. Again, you need to be here in person on May 23rd of 2023 at 9 a.m. You're free to go, and you have a blessed day.
Thank you. Likewise.
Thank you. The next two cases are cause numbers 25 CCCR 0130 and cause number 25 CCCR 0131. Both cases are style of state of Texas versus Justin Diaz. Mr. Diaz is appearing via Zoom. Mr. Diaz, you can take your mic off of mute. Mr. Diaz, how are you doing?
Sir, doing good, sir.
You doing all right? Okay, now, Mr. Diaz, you're represented in your case by Mr. Paget. Mr. Paget, what are your announcements in Mr. Diaz's cases?
Your Honor, we have not completed discovery. We're in the process of doing so. You would give us 30 days. I'm quite certain I can have an offer and discovery completed.
30-day reset, it's gonna be the same day. Okay, it's gonna be the same date, May 23rd, 2025 at 9 a.m. Mr. Diaz, stay in contact with your attorney and your bondsman. They will be given notice of your reset dates. Your reset dates is May 23rd, 2025 at 9 a.m. You're free to go, and you have a blessed day.
Thank you, sir.
Okay,
Well,
Mr. Paget, your recess will be sent to you. You're free to go as well. I think this is your last client. You're free to go, and you have a blessed day.
Yes, Your Honor. You have a blessed day as well. Thank you.
All right, thank you.
Yes, sir.
Let's be dismissed.
That one we finished.
Jasmine Gasaway? No, Jasmine McDaniels. This is cause number 24 CCCR 0522, case is style the state of Texas versus Jasmine Nicole McDaniel. Ms. McDaniel, is that your full name? How are you doing, Ms. McDaniel? I'm doing fine, thanks for asking. Ms. McDaniel, you are representing your case by your attorney, Christy Cawthon. Attorney Cawthon, how are you doing?
Doing well, Your Honor. How are you?
I'm doing fine, thanks for asking. Ms. Simmons, I have before me a motion to dismiss in Ms. McDaniel's case? Is that
Yes, Your
correct?
Honor, the state's dismissing at the request of the complaining witness.
Okay. Now, Ms. McDaniel, I'm signing the motion to dismiss. You'll be able to get a copy of this motion in a few minutes from our court coordinator. Once you get a copy of this motion, you'll be free to go. You have a blessed day. Please stand in front of the court coordinator. And Ms. Calkin, is this your only case?
Yes, Your Honor.
Okay, you're free to go. You'll be free to go as well. You have a blessed
Okay,
day.
thank you, Your Honor.
You're welcome.
Appreciate it.
Signed it.
You talking to me, Mosby?
Yeah, that was a business.
Yes, ma'am.
Next case is Larry Jean Dupuy. Would you come forward, Mr. Dupuy? Stand right there in front. Mr. Dupuy, your full name is Larry Jean Dupuy.
Yes, sir.
How are you doing, Mr. Dupuy? That's good, Mr. Dupuy. You represented in this case by your attorney Ryan Gertz, who is appearing via Zoom. Mr. Gertz, how are you doing?
Good, Judge. How are you?
I'm doing fine, thanks for asking. Now, Mr. Gertz, what is your announcement in Mr. Dupuy's case?
Judge, this is the case that was originally in County Court number 3 and was on the trial docket over there and then got moved to your court. So we'd ask that it just be put on your trial docket, please.
Okay, hold on a minute. Where's the bond conditions? Bond conditions. I see he has, you're gonna give us a reset date? June 9th?
I'll be there. The only week I won't be in this court is June. The only week I won't be in this court is June 2nd.
Okay. Mr. Dupuy, your case will be set for trial on June 9th, 2025 at 9 AM. On that day, you need to be in court with your attorney. You'll be set on the trial docket. Seems like this case is a 2023 case. It was on that docket for about 407 days. County Court Law number 3, so. What we're going to do, we're gonna put you on our trial docket. Okay, now, before I give you a reset, I need to give you some bond conditions. This is standard bond conditions in County Code at Law number 2. Say following return of a criminal information in County Code at Law number 2 of Jefferson County, Texas. All bail bonds are executed for release of any defendant named herein or order subject to the additional conditions. Number 1, The defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. However, condition number 4 does apply because your case, which is a DWI second, is a subsequent offense that is listed under section 49.04 through 4906 of the Texas Penal Code. Condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes it practical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the day. I noticed, I'm looking at your file,
I've had it since.
and it says that you have a Smart Start, September 13th, 2024.
No,
that-
so 23. They asked
Oh.
me for the documentation for proof, I think, in September 24. But I had to put on exactly after the incident in 23.
Okay,
And it's been on there since.
okay, so we have documents in the file.
Yes.
Now, you shall obtain, maintain, and pay for, and have no violations with the ignition, interlock device, mobile breath device. Any violations will be grounds for revocation. Do you understand that? Now, condition number 6, the defendant must attend AA, NA meetings 3 times a week and provide proof to the court. I have a verification form that you can bring with you to those meetings. And every time that you come into court, you need to have this form with you so that we can verify that you have been attending. And also, I have a list of locations that you can, that have AANA meetings, okay? Would you please step to your left? You get this information? Okay, now, if you violate any one of these bond conditions, your bond can be revoked. If your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Your case is being reset for trial June 9th, 2025. And you can get a copy of the reset from our coordinator. Once you get a copy of the reset, you're free to go, and you have a blessed day. Please stand in front of the coordinator. And Mr. Gertz, your reset will be sent to you.
Thank you, Judge.
Okay. Brenton Allen Hope. Please come forward. Huh? Okay. I hadn't finished signing. Okay, Mr. Hope, your full name is Brenton Allen Hope. Okay, Mr. Hope, how are you doing? I'm blessed as well. You represented in your case by your attorney Ryan Gertz. And Mr. Gertz, what is your announcement in Mr. Hope's case?
Judge, what's the offense date on this particular cause number?
This case was transferred from County Court 3. The offense date is February 28, 2023.
Okay. So Judge, I think for some reason, this may have fallen through the cracks while we were dealing with his felony case that has a different offense date. And we got that case dismissed in felony court. So I think I don't have discovery in this case. for that reason. I'm not sure why, but we got I'm looking at all the felony discovery that we had, but we don't
Right.
have this. So
It's been 2 years, huh?
I'll release the paper discovery to you in just a moment, Mr. Gertz, if you'll go ahead and send in a media request.
okay, thank you. We'll do it.
Okay. Okay, this case is gonna be reset for announcement. Give us a reset date. Okay, this case was reset to May 28th of 2025. You're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall. Thank you. Stacy Robinson. Miss Robinson, your full name is Stacy Robinson. Okay. How are you doing, Miss Robinson? That's good, Miss Robinson. You were represented by Ryan Gertz, who's appearing via Zoom. Mr. Gertz, what is your announcement in Ms. Robinson's case?
Judge, we requested discovery, I think about 2 months ago. We looked again this morning on the portal. It still has not been released to us.
Okay, hold on a minute. Anybody have your phone on? You need to turn your phones off, put them on silent. Okay? If not, we can hold you in contempt of court. And contempt of court carries a 6-month period in jail and a fine that does not exceed $500. Okay? So at this time, everybody, please turn your mics, your camera, your telephones off, or you can do and put it on silent. Okay, now, Mr. Gertz, how much time do you need again?
Well, Judge, I don't know what the nature of the discovery is going to be, so I don't know the answer to that yet.
Okay, we'll just give you a standard discovery then. The
This is Mr.
standard.
Pugel's case, but I'll send discovery in real quick as well. If you'll do the media.
Okay,
request.
we'll give you a standard 20. Okay, now this is a DWI second. Yeah. Okay, now Miss Robinson, your case is a DWI second, and they have some standard bond conditions from County Court at Law number 2 that I need to give to you. And I'm gonna read these conditions to you. And then you'll be able to get a copy of these conditions from our court coordinator. And the bond conditions are as follows. Following return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 does not apply. However, condition number 4 does apply because your case, which is a DWI second, is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states as follows. A defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. Do you understand that condition? And condition number 5 states defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition? And condition number 6, defendant must attend AA/NA meetings 3 times a week and provide proof to the court. And I have before me document, I have a verification form and locations of AA/NA meetings in our area that you can choose to attend. The bailiff is going to hand these documents to you. Now, every time that you come back to court, you need to bring the verification forms back to court so that we can verify that you have been attended. Now, this will conclude your case. Your case is going to be reset. Please have a seat in that chair and wait for your name to be called. And once your name is called and you get your reset, you're free to go and you have a blessed day. And Mr. Gertz, your reset will be sent to you. You're free to go and you have a blessed day. What's that reset date?
Judge, I may have one more with you.
Okay, hold on.
I'm happy to leave if you want me to, but I think I've got one more.
He does?
He does. Fabric.
Oh, okay. Kenny Wayne Chadwick. Okay, this is cause number 25 CCCR 0094, case is style of state of Texas versus Kenneth Wayne Chadwick. Mr. Chadwick, is that your full name?
Yes, sir.
How are you doing, Mr. Chadwick?
I'm well, how are you?
I'm doing fine, thanks for asking. Mr. Chadwick, represented by your attorney, Ryan Gertz. Mr. Gertz, what's your announcement in Mr. Chadwick's case?
Judge, we're still waiting on the video in this case. We've got the paper discovery. I'm not certain. I'm double checking with my office whether we've sent a media request or not, but he is not. We've not received it.
Okay, give us a reset date. May 28th. Mr. Chadwick, your case will be reset to May 28th, 2025 at 9 a.m. You'll be able to get a copy of this reset from our court coordinator. Once you get a copy of the reset, you're free to go. And you have a blessed day. Please have a seat in that second chair on the wall and wait for your name to be called.
Thank you, sir.
Okay. Oh,
That's it.
okay. Oh, yeah. Sitting up on the knees.
Yeah, go for something.
Here you go.
I sent you one.
We can recall.
Okay,
Mr.
let me
Forbes.
give me those gloves.
Because Manuel Sanchez will leave at the chair.
The Chadwick was reset to May 28th, 2025. Okay. And what's the gentleman's name? Is it Manuel Sanchez? Oliva?
Yes, Judge, he's on here.
Okay, he's trying to get on. He's trying to take his mic off of mute.
Okay,
Okay, how you doing there, Mr. Sanchez Oliva?
good, sir. You?
Okay, now, Mr. Sanchez Oliva, your case is set for trial on Monday, the 21st of April. Court informed you that you had to be back in court at 1:30 on that same day. You did not appear. State moved for a bond forfeiture. Your attorney appeared in court earlier, informing the court that on that day, he was informed that there was a case before yours that was going to go to trial. And he informed you that you did not need to appear. Is that correct?
No entendí todo.
What he said?
I think he's having a hard
He
time.
said,
understanding.
Oh,
he said, I did not understand everything in Spanish, Judge.
okay. Could you, Mr. Gilthart?
Yes, Judge.
Mr. Oliva was scheduled for trial at 1:30 on Monday. Is that correct?
That's correct, Judge.
And he was informed that he needed to be in court. During our 9 o'clock session, he was informed that he needed to be in court at 1:30. Is that correct?
That's correct, Judge.
And earlier you stated that you were informed that there was a case that was set before your case, and that case was going, and so you informed him not that he did not have to appear. Is that correct?
That is correct, Judge.
Okay. Now, and you could ask Mr. Oliva if that's correct.
Yes, Your Honor. Señor Oliva, él le está preguntando que si el lunes él le mandó a corte para aparecer a la 1 de la tarde, pero después de esto, yo le dije que no tendría que ir. Así es, ¿no?
Sí, yes.
Okay. So, the court will find that that there was an uncontrollable circumstance that prevented Mr. Sanchez Oliva appear in court. It was no fault on his part, and Mr. Oliva has appeared in person. So pursuant to Article 22.13 of the Texas Code of Criminal Procedure, this case, this forfeiture will be set aside. State, do you have any objections?
No, Your Honor.
Okay, no objections. The bond forfeiture is set aside. Now, we have to give we gave him a trial date. Okay, your case will be reset for trial on June 9th, 2025 at 9 a.m. And on that day, Mr. Oliva, you need to be here in person with your attorney. Okay, you could explain that to him, Mr. Gilthart.
Yeah, right. Hola, señor Oliva, entonces él le está quitando el orden que tenía, entonces le están poniendo otra fecha más y en ese día tenemos que aparecer en persona y entonces ya está bien.
Todo está bien ya ahorita porque pues yo sí sé lo que
Sí.
y entonces sería hasta cuándo voy a regresar.
Judge, what is the date on the new setting?
What's that date? It's June 9th. June 9th.
El 9 de
2025.
junio.
¿De junio?
El 9 de junio. Sí.
Okay. So you're free to go and you have a blessed day.
Okay.
And Mr. Gilthorpe, you're free to go as well and you have a blessed day. You can tell your client he's free
Thank
to
you,
go.
Judge, and I appreciate it.
You're welcome.
Ya, señor Manuel, ya se puede colgar.
Ok, muchas gracias. Muchas gracias, juez.
He says, thank you, Judge.
Okay, you're welcome. Yeah, y'all free to go. Y'all have a blessed day.
Bye-bye. Thank you.
Kendall Hunter May. Court is in session in 2 cases. Cause number,
Your Honor, there's 3
I don't-
cases.
I only see one on the docket. Oh, wait, the other 2 in the back?
They were added to the docket, Your Honor.
Oh,
There are 2 new cases that were filed recently. Did you receive both dismissals?
I see one. Okay. 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 Cases are cause numbers 24 CCCR 2946. Cause number 25 CCCR 0925. And cause number 25 CCCR 0926. All 3 cases are styled the state of Texas versus Kendall Hunter May. Mr. May, is that your full name?
Yes, sir.
Mr. May, would you please raise your right hand? Mr. May, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. May, you may put your hand down. How are you doing, Mr. May?
Pretty good.
That's good. Mr. May, you're represented in your cases by your attorney, Attorney Ryan Matuska. Attorney Matuska, how are you doing?
Morning, Your Honor.
Good morning. Now, Mr. Matuska, do you waive a record in Mr. May's cases?
Yes, sir, Your Honor.
He wasn't in here when I gave that announcement. Why don't you go outside and tell him what I just informed everybody else? He wasn't in here when I made the announcement. Ms. Mosby?
I told him.
Okay, he needed. Okay, now, make sure, Mr. Boudreaux, make sure your phone is either off or on mute. Or you can just turn it off. Or you can put it on vibrate. Okay, now, Mr. May. I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Kendall Hunter May, on or about June 2nd of 2024, while you were operating a watercraft, in Jefferson County, Texas, when you were intoxicated, and you've been charged with the Class B misdemeanor offense of boating while intoxicated. Mr. May, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Okay. Have Mr. Stank go outside. You pleading guilty? Is that correct?
Yes, sir.
That's your plea guilty? Okay. Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay. Mr. May, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
Now you see a word scratched out. I scratched out driving and I replaced with boating. And on page 2 of this same document, there are a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. May, before you signed and initialed all of these documents, did your attorney, Mr. Matuska, go over these documents with you?
Yes, sir.
Did you understand everything that Mr. Matuska went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. May, are you a citizen of the United States?
Yes, sir.
State up for states one.
Any objections to state's exhibit number one?
Objection.
No objection, state's exhibit number one will be admitted. Mr. Matuska, you have advised and counseled Mr. May. Is there any evidence that he is currently mentally incompetent to stand trial?
None whatsoever.
And Mr. May, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
And has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. May, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 90 days prorated over 1 year, $500 fine, 50 hours community service, interlock and stated conditions of probation. State's also going to dismiss the companion case ending in 0926 with forfeiture of all three weapons and dismissal of the cause ending in 0925 for the plea for this case.
What's the court cost? Yeah. It's a BWI. It's a BWI. Okay, Mr. May. The state is offering that you serve 90 days in jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500. You will also be required to pay court costs of $377. You'll also be required to pay a boating while intoxicated fee of $100. You'll also be required to pay a probation fee of $6 a month, unanimous fee of $15 a month, reimbursement fee of $15. Your You will also be required to pay Jefferson County DW Education and initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $172 a month. Will you be able to pay the $172 a month?
Yes, sir.
You'll also be required to perform 50 hours of community service, install an interlock device on any vehicle that you own or operate. Attend and complete a DW education class, have an alcohol assessment, adhere to the other standard terms and condition of probation. The state will be dismissing cause numbers 25 CCCR 0925 and cause number 25 CCCR 0926. And in that case, I have before me a motion to forfeit the weapons in cause number 25 CCCR 0926. Do you recognize this motion?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And before you signed this document, did your attorney go over this document with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes.
I'm signing this motion to forfeit the weapons to the Port Arthur Police Department. Mr. May, do you understand the state's offer?
Yes, sir.
Do you think that state's offer in your case is fair and just?
I do.
And do you accept the state's offer?
Yes, sir.
Okay. Mr. May, I'll follow the plea bargain agreement that you have entered into with the state. Mr. May, this will conclude your cases. You will stand at the end of the counter next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you, sir.
You're welcome. Dylan Spivey. Okay, this is cause number 24 CCCR 0648. Case is filed in the state of Texas versus Dylan Spivey. Mr. Spivey, is that your full name?
Yes, sir.
How are you doing, Mr. Spivey? I'm doing fine, thanks for asking. Spivey, you're representing your case by your attorney, Ryan Matuska. Mr. Matuska, what is your announcement in Mr. Spivey's case?
Your Honor, we're asking that the case be placed on the trial docket.
Okay. What is that court date? Okay, this case will be reset to June 2nd of 2025 at 9 a.m. And this case is set for trial. Mr. Spivey, you need to be in court on that day in person. And you'll be able to get a copy of this reset from our court coordinator in a few minutes. Just have a seat in that second chair and wait for your name to be called. You're welcome. And Mr. Matuska, you're gonna get your reset. You'll be free to go. And you have a blessed day. And also I have those dismissals.
I think that's all I need.
Hmm?
I believe that was more.
Yes, you're free to go. Russell Bean. Russell Thomas Bean. I see him. Mr. Bean, you could take your mic off of mute. Mr. Bean, you can take your mic off of mute.
Yes, Your Honor.
Okay, Mr. Bean, how are you doing?
I've been feeling pretty bad today, the past couple of days, Your Honor.
Okay, we'll be praying that you have a full and speedy recovery from your illness. Now, Mr. Bean, you're represented in your case by your attorney, Attorney Giles Cole. Attorney Cole, how are you doing?
Great.
I'm doing fine. Thanks for asking. State is represented in this case by Attorney Haley Simmons, and the probation office is represented by Ms. Jennifer Reeves. Ms. Reeves, how are you doing?
Good.
Okay. And Ms. Simmons, what's the state's announcement?
This time, we've been made aware by probation that the defendant has not paid any of his fees as well as community service. He has done absolutely nothing on probation. He needs to be here in person so we can dispose of the case promptly.
Okay,
I understand that he's sick. If he could provide documentation for that, we could do a short reset to get this case disposed of. There was an original agreement back in March, and I'm speaking for defense as well, but we had communication where he was supposed to pay all fees by March 20th, which he did not have done.
oh, okay.
Hold on.
Give us a 2-week reset. Oh, what's the date? Okay, this case will be reset to May 7th of 2025. And Mr. Bean, you need to be in court on that, in person on that day, okay?
Yes, Your Honor.
Okay, you're free to go. Again, we pray that you have a full and speedy recovery. Stay in contact with your attorney and bondsman because they will be giving notice of your reset date. And you have a
Thank
blessed
you,
day.
Your Honor.
All
Yes,
right.
sir.
And Mr. Cole, yeah, you excuse me, see you at 1 o'clock. Yeah. Oh, before. Hey,
He Jaws.
yeah. Oh,
This is Mr. Hugel's case. You're
Ah,
going to set it.
okay,
set
my,
it for-
the coordinator stepped out. Okay. So you're gonna set it for trial?
Yeah.
Now, Mr. Kibiter, your case is gonna be set for trial when the coordinator step back in. She's gonna give you your trial date. Once you get your trial date, you're free to go and you have a blessed day. So please have a seat in that first chair on the wall.
Leave.
And this is the only case, Mr. Kimber?
I believe.
Yeah, you're free to go and you have a blessed day. Full name is Jennifer Lynn Ripley.
Yes, sir.
How you doing, Miss Ripley?
Very good, sir.
I'm doing fine, thanks for asking. Ms. Ripley, I have a motion to dismiss that was submitted by the state, is that correct, state?
Yes, Your Honor.
And I'm signing this motion to dismiss. You'll be able to get a copy of this motion in a few minutes.
She's gonna hear you.
You can have a seat in that second chair on the wall.
The
Wait.
monitor, I can get the monitor removed.
Oh, is that, there's a monitor on?
I have a
Okay,
monitor.
GPS.
Thank you.
Hold on a minute. I need to sign that.
Is that a monitor on?
Okay.
They're still in the bed. Oh, that is the thing.
Is it, hold on, make sure it's a GPS.
Yes, sir. Yes,
And that was a condition of a bond, right?
yes, sir.
Now, let's make sure it came from here. Ripley. Today, the 23rd. Okay, yeah, just sign the order. And you can get a copy of it. If they need a certified, you would have to go downstairs and get a copy from the county clerk's office. But it, okay, you can stand in front of coordinating. The sudden surprise, Stevens. Hmm? You say you have a paperwork. Oh. Ms. Stevens, would you please come forward? Ms. Stevens, your full name is LaSudden Surprise Stevens, is that correct? Okay, how you doing, Ms. Stevens? You doing fine? Okay, now, Ms. Stevens, I have, okay, first of all, Ms. Stevens. Okay, Ms. Stevens, the cause number M332608, have before me a motion to revoke probation that was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, the sudden surprise Stevens, was tried in County Court at Law Number 2, Jefferson County, Texas, November 1st of 2023 for the offense of deadly conduct. which is a Class A misdemeanor. And you were found guilty and your punishment was assessed at 180 days confinement in the county jail, a fine that does not exceed, and a fine of $500. The confinement was probated for a period of 2 years. In this motion, there are 5 allegations. Allegation number 1 alleges that you, LaSutton Surprise Stevens, committed the offense of resisting arrest on or about February 19, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. Allegation number 2 alleges that you, LaSutton Surprise Stevens, failed to provide verification of completing a moral recognition therapy program in violation of condition 8, condition 4 of your probation order. Allegation number 3 alleges that you, LaSutton Surprise Stevens, failed to work faithfully at a suitable employment as possible as ordered by the court in violation of condition 6 of your probation order. Allegation number 4 alleges that you, LaSutton Surprise Stevens, was at a location other than your resident at approximately 11:29 p.m. on or about the 18th day of February 2025 when you were arrested by Beaumont Police Department in violation of Exhibit A, Condition 2 of your probation order, and allegation number 5 alleges that you, LaSutton Surprise Stevens, failed to pay court assessed fees as ordered by the court, and as of February 24, 2025, you $720 in arrears in violation of Condition 9 of your probation order. Now, Ms. Stevens, if the court finds that any one of these allegations are true, your punishment can be assessed at 180 days in the jail. Next case is cause number M332610. And in this case, Ms. Stevens, I have before me a motion to revoke your probation that was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, LaSutton Surprise Stevens, was tried in County Court Number 2, Jefferson County, Texas, on November 1st, 2023, for the offense of lawfully carrying a weapon, the Class A misdemeanor. You were found guilty, and the punishment assessed 180 days confinement, Jefferson County Jail, without a fine. The confinement was probated for a period of 2 years. In this motion, there are 6 allegations. Allegation number 1 alleges that you, LaSutton Surprise Stevens, committed the offense of resisting arrest on or about February 19, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. Allegation number 2 alleges that you, LaSutton Surprise Stevens, failed to provide verification and complete a moral recognition therapy program in violation of Exhibit A, Condition 4 of your probation order. Allegation number 3 alleges that you, LaSutton Surprise Stevens, failed to work faithfully at suitable employment as far as possible as ordered by the court in violation of Condition 6 of your probation order. Allegation number 4 alleges that you, LaSutton Surprise Stevens, failed to perform community service hours required as ordered by the court in violation of Condition 17 of your probation order. And allegation number 5 alleges that you, LaSutton Surprise Stevens, was at a location other than your residence at approximately 11:29 p.m. on or about the 18th day of February 2025 when you were arrested by the Beaumont Police Department in violation of Condition 8, Condition 2 of your probation order. And allegation number 6 alleges that you, LaSutton Surprise Stevens, failed to pay court assessed fees as ordered by the court. And as of February 24, 2025, you were $362 in arrears in violation of Condition 9 of your probation order. And Ms. Stevens, if the court finds any one of these allegations in this motion to be true, you can be assessed up to 180 days confinement in the Jefferson County Jail. Do you understand? Okay, now, Ms. Stevens, I have before me, well, first of all, you have a right to have an attorney, and I have before me judge's explanation of rights of defendants without an attorney. And do you recognize this document? Could you, you would give both of these documents? The first document is judge's explanation of defendant's rights without an attorney. You recognize that document? Is that your signature on the line that's titled defendant? Or those are your initials on the line that state you'd like to apply for a court-appointed attorney? The next document is Jefferson County Affidavit of Indigence. Do you recognize that document? And on page 2 of that document, there's a signature above, at the top left-hand corner, above the line that is titled defendant signature. Is that your signature? Now, Ms. Stevens, before you signed and initial those documents, did you read the documents? Did you understand what you read? And is everything in those documents true and correct to the best of your knowledge? Let me see. Okay, Ms. Stevens, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be then I think I didn't list some names yesterday. Hold on a minute. Ms. Stevens, your attorney in this case will be Christy Carlton. Ms. Carlton will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. Yeah. Okay. Once she gives you that information, you'll be free to go and you have a blessed day. Court is in session in cause number 24 CCCR 2808. Case is Tyler, State of Texas versus Michaela Taylor. Ms. Taylor, is that your full name? How are you doing, Ms. Taylor? I'm doing fine, thanks for asking. Ms. Taylor, you're represented in your case by your attorney, Tyler LeBlanc. Attorney LeBlanc, how are you doing?
I'm good, Judge.
And Mr. LeBlanc, what is your announcement in Ms. Taylor's case?
Judge, I need to talk to her about it. If we can reset it, another court's in trial and drug court's asking me to come back over there. I don't think that this has been reset.
Okay, so you want to reset it for an announcement?
Yes, Judge.
Give us a reset date. May 23rd. Okay, this case is reset to May 23rd, 2025. Ms. Taylor, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go. Please have a seat in that second chair on the wall. And Mr. LeBlanc, this is on the case. You're free to go and you have a blessed day.
Thanks, Judge.
Jeremy Johnson. Okay, this is cause number 2460CR 0694, case of Tyler State of Texas versus Jeremy Johnson. Mr. Johnson, is that your full name? Jeremy Kelly Johnson. How are you doing, Mr. Johnson? That's good. Now, Mr. Johnson, you're represented in your case by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
Hey, Mr. Boudreaux, what is your announcement in Mr. Johnson's case?
Your Honor, I've tried to get a hold of the DA's office a couple of times and I haven't gotten any response, so could we have a minute and we'll.
Okay, I hope you can have a seat. We'll.
Can we
bring
take a
back.
brief recess?
Yeah.
Bring it back.
Okay, yeah, we'll take a recess. At this time, the court will be in recess. And we're waiting on the on your lawyers to show up. Okay, Jessica Hawkins, is it Jessica Monet Hawkins? Okay, how are you doing, Ms. Hawkins? I'm doing fine. Ms. Hawkins, your case, we set it for a status hearing, is that correct?
Yes, Your Honor. We conducted an administrative hearing back in February. And we were just letting the court know that we were going to review the case in 90
Right,
days.
right.
Then you put it on your docket, which, like I said, is fine.
Right,
She agreed within the 90 days to pay $1,000 on her fees. She's about $100 short, which,
Okay.
I mean, $900
Yeah,
is
right.
a lot. I'm just asking that she just continue. We may have to request one more extension but she did what we asked her to do for the.
Okay, now, do you have an extension?
I haven't discussed that with her to see how much more time she'll need to pay the remaining balance. So I'll meet with her, this, next week, next Tuesday.
April 29th.
Yeah, next Tuesday we'll discuss how
Okay.
much she needs, but she,
And so-
she did what we asked her to do.
Okay, so we'll just wait to hear from the probation
Yes, sir.
department.
Yes, sir.
And then,
So there will be not another hearing unless there are new violations, but I don't.
Right.
that's gonna be-
okay. Okay, Ms. Hawkins, just stay in contact with your probation officer, appear to the court that you are in compliance or substantial compliance with what they have asked you to do. Okay?
Okay.
So just keep up the good work.
Thank you.
You're welcome.
I think we're gonna announce one.
Okay, Jeremy Kelly Johnson. Okay, now, Mr. Boudreaux, what's your announcement?
Your Honor, the state has made a reduced offer. May we have about a week or two so I can talk to him about it, or because I think he may want a trial because he doesn't think that.
Okay, well, I mean, you don't have to get into the reason why he wants to try. If you want to try, I mean, that'll be fine. So we just reset it for an announcement, right? And you say 2 weeks? That's what y'all saying? You should be able to make his decision? Okay. Let's give a 2-week reset. Okay, this case will be May 9th, 2025. Okay, now, Mr. Johnson, I know earlier, when I was coming into the courthouse, said you wanted to talk to me about a case, and I informed you I couldn't talk to you about a case. Is we have rules that we must abide by. We have what they call a code of judicial conduct. The court cannot discuss your case. What we call, the term is called ex parte. Now, if the state and the defense has to be present for any discussion of the case, that's why I told you that when you come to court, we'll talk about your case in the courtroom. Okay? All right. So you're going to get your reset. Your case is reset to May 9th, 2025 at 9 a.m. You're going to get your reset. Once you get your reset, you're free to go and you have a blessed day. We need to get in contact with Mr. Okay, court is back in session and calls number 24 CCCR 2524, case of Salas, State of Texas versus Bobby Glenn Watkins. Mr. Watkins, is that your full name? Mr. Watkins, how are you doing? You okay? Mr. Watkins, would you please raise your right hand? Mr. Watkins, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Watkins, you may put your hand down. Mr. Watkins, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that is titled Defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? Mr. Watkins, I also have another document that is titled Jefferson County Affidavit of Interest. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Yes. Mr. Watkins, before you signed and initialed these documents, did you read the documents? Yes. Do you understand what you read? Yes. Is everything in these documents true and correct to the best of your knowledge? Now, Mr. Watkins, I was reviewing the your take-home pay. I don't think you qualify for the appointment of a court-appointed attorney. Let me do this here. Okay, Mr. Watkins. Now everything on this document, affidavit is true, is correct to the best of your knowledge? Okay, Mr. Watkins. Court finds that you meet the eligibility requirements for the appointment of full appointed attorney. And the attorney that will be appointed to represent you, in this case, Attorney John Cole. Attorney Cole will be given information to contact you. And you will be given information to contact him. Court coordinator will give you that information. Once she gives you that information, you're free to go. You have a blessed day. Please stand in front of the court coordinator for your reset. Here you go. Court is back in session in cause number 24-CCCR 2830, case of style of the state of Texas versus Ariel Anelsa Mouton. Ms. Mouton, would you please come forward? Ms. Mouton, your full name is Ariel Anessa Mouton? Ms. Mouton, would you please raise your right hand? Ms. Mouton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Mouton, you may put your hand down. How are you doing, Ms. Mouton? That's good, Ms. Mouton. You're representing your case by your attorney. Attorney Jennifer Delage. Ms. Delage, how are you doing?
I'm doing good, Judge.
And Ms. Delage, do you waive a record in Ms. Mouton's case?
Yes, Your Honor.
Ms. Mouton, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ariel Anelsa Mouton, on or about November 6th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Mouton, do you understand what you've been charged with? To this charge, Ms. Mouton, how do you plead guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, Ms. Mouton, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of the same document, there's a set of initials on a line next to a box that's checked no contendere, which means no contest. Did you place your initials AM on this document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document? Now, Ms. Mouton, before you sign and initial these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? And Ms. Mouton, are you a citizen of the United States?
State up for 6-1.
Any
No
objections?
objection.
No objections. State's exhibit number 1 will be admitted. Ms. Delage, you advising counsel, Ms. Mouton, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Mouton, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes.
Okay, Ms. Mouton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the
In
agreement?
exchange for defendant's plea, the state's offering 1-year deferred probation, $200 fine, 40 hours community service, vet class and court cost.
What's the court cost? And Mr. Lodge, will you report it?
Yes, Your Honor. 350, I believe, yeah.
Yeah. Okay, Ms. Mouton. The state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a fine of $200 for court costs, or $277. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, a reimbursement fee, $15, and you will be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $158 a month. Will you be able to pay the $158 a month? You will also be required to perform 40 hours of community service. You'll be required to attend and complete a theft class, and you'll be required to adhere to the other standard terms and conditions of this probation. Ms. Mouton, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Ms. Mouton, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Mouton, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record. You may qualify for a non-disclosure whereby your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because she's quite competent in those matters. Now, Ms. Mouton, this will conclude your case. You will stand at the end of the counter next to the bailiff and follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day.
And Judge, am I free to go?
Yes, you're free to go as well, Mr. Lodge.
Although I'm not really free to go, I got to go to jail and stuff, but. I'm not going anywhere. Hey.
Okay. Jefferson County Court at law number 2 is back in session. The court is in session with its announcement docket. Next case is cause number 24CCCR 2828. Case is filed, the state of Texas versus John Glenn Duhon. We have Mr. Duhon, who's present in court. Mr. Duhon, is that your full name?
Yes, sir.
Okay, Mr. Duhon is represented in this case by his attorney Tom Burbank, who is appearing via Zoom. Mr. Burbank, how are you doing?
Doing fine, Judge.
And Mr. Duhon, how are you doing?
I'm all right, sir.
Okay, now, Mr. Burbank, what is your announcement in Mr. Duhon's case?
Because the state won't dismiss the charge, Judge, we're going to have to ask to be placed on the trial docket.
Okay, give us a reset date. Okay, this case will be reset to June 2nd, 2025. Mr. Burbank, your reset will be sent to you. And Mr. Duhon, you're going to get your reset here in court. Once you get your reset, you're free to go. You have a blessed day. Please stand in front of the court coordinator. And Mr. Burbank, you're free to go. Your reset will be sent to you and you have a blessed day.
Thank you, Your Honor.
Okay, you may be seated. Jefferson County Court at Law number 2 is back in session. Court is in session and cause number M330658. Case is style of state of Texas versus Cody Clinton Williams. Let the record reflect that Mr. Williams is present in court with his attorney Giles Cole. State is present with Assistant District Attorney Haley Simmons and Attorney Kyle Gasper. Let the record reflect that the jury is also present and seated in the courtroom. State, are you ready?
State's ready, Your Honor.
And defense, are you ready?
That's right.
Ladies and gentlemen of the jury, at this time, the court is going to read to you the court's charge. Members of the jury, the defendant, Cody Clinton Williams, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. And the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. The offense is alleged to have occurred on or about the 13th day of July 2021 in Jefferson County, Texas. The defendant entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances, or any other substance into the body, or by having an alcohol concentration level of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes but is not limited to streets, highways, and the common areas of schools, hospitals, apartments, houses, office buildings, transport facilities, and shops. Alcohol concentration means the number of grams of alcohol per 210 liters of breath, 100 milliliters of blood, or 67 milliliters of urine. Now bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 13th day of July, 2021, in Jefferson County, Texas, the defendant, Cody Clinton Williams, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, and that the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will find the defendant guilty as charged, unless you do so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will next consider whether the defendant is guilty of the lesser included offense of driving while intoxicated. Now bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 13th day of July, 2021 in Jefferson County, Texas, the defendant Cody Clinton Williams did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, then you will find the defendant guilty of driving while intoxicated. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. General instructions. All persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilt, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted in evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict page attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page is the verdict form. It has 3 sections. Your foreperson will only sign 1 section. If your verdict is, we the jury find the defendant not guilty, then your full person will sign the top line that says full person. Or if you decide that we, the jury, find the defendant guilty of driving while intoxicated and blood showed an alcohol concentration level of 0.15 or more at the time an analysis was performed, then your full person will sign the second line where it says full person. Or if the jury decides that we, the jury, find the defendant guilty of a lesser included offense of just driving while intoxicated, then you will sign here. Does everyone understand? Okay. Okay. Attorneys, would 20 minutes be enough?
20 minutes fine, Your Honor. The state's gonna be waiving right to open and reserving right to close.
20 minutes will be enough? Okay. Now, each side will be given 20 minutes to close. State is waiving their right to open, and they will be reserving their right to close. So at this time, Mr. Cole, you may proceed, and I'm keeping the time.
Good to see everyone. How y'all doing? This happened a few years ago. Of course. Get back there to the jury room. I want you to observe the police officers as they're perceiving that car. You're going to hear them talking. No one says anything about that car being running. They call out everything. They'll talk. It wasn't until they asked him to roll the windows down. Roll the windows down. Roll the windows down. Cody had to roll the windows down. When you turn the car. When you look inside that vehicle, I want you to look at the lights. No lights came on. No lights turned off. That vehicle was not on when they walked up. See, they get to go back and they get to get all these, dot their I's and cross their T's. And they know how to make things fit the elements that they need to get that charge. So, because they got everything else. You got the blood. They got a witness who finds you saw him swerve. I've swerved because I was on the phone. Doesn't mean that. Doesn't mean he's a topic. I want you to watch carefully. Watch him knock on the window. Observe them walk into that car. I've never seen a police officer when they're walking to a car, not knowing what it's about. And they're talking to each other. None of them say the car is running. I've seen them touch it just to feel it. None of them done that. They walked up in there. They couldn't see inside. Hey, watch as Cody rolls that window down. They open the door. The other officer on the other side, hey, turn the car. Meaning, get the keys out the ignition. Because that's what Cody did. In order to roll that window down, he had to turn the key, hit the button. That car is electric, and you'll be able to see that. So that's what I'm asking you to do, because he was not operating that vehicle. He drank whatever he had to drink inside that vehicle. And it's easy to work 12 hours and hell, crash out in the car. I don't know what the temperature was that day. Cody said it was 120 degrees. I don't know. I didn't go look at the weather on. So I think that's where this case hinges. Did he drink that alcohol inside that car with the drink? Our argument is that he was in that vehicle. The car was not running when they pulled up. What they have is open container case, not a driving vehicle under influence. That's what I'm asking you to do today, folks. This is pretty simple. Look at it. Whatever you come up with, we're gonna live with. But I truly believe that Cody fell asleep. Can't remember it. So, with that being said, I'm gonna wrap this up. Before I can return the verdict. Thank you.
Ms. Simmons?
Good afternoon. I'm a little bored, excited to get out of here by the end of the day. I want to key on a few things. We talked about the elements we talked about in my opening, whenever I laid out the checklist that I wanted y'all to have. We all have checklists. We all have something to do when we're getting off work today or whenever you're leaving the jury room. We all have something to do. Right now, I want you to, I'm gonna go over the elements and they're not up here on the screen. Follow that checklist with me. Okay? I'm gonna kind of use the defendant's own words here, and you heard him testify on the stand. It doesn't make sense. You're right. A lot of it doesn't make sense. What he wants you to believe is that on July 13th of 2021, he pulled over on the side of the road and fell asleep for God knows how long, 5 to 7 hours, and drank 1 beer. Let me ask you something. We're all intelligent, smart people. We can math to an extent, right? I'm not an engineer, but I can have numbers. You're gonna go back, you're gonna have the opportunity to look at State's Exhibit 4, and you're gonna see that the blood alcohol concentration was 0.172. Texas legal limit, 0.08. 1 beer, and he manages to be over double the legal limit. You know, defense counsel got up here and they just said police officers walked up not knowing what they were walking into. That's not true. Mr. Ayler got on the stand. He testified to the fact that he called police. He followed the vehicle until the point that it stopped. Obviously operating, obviously running. Car was on. He waited for police to arrive. Police arrived. They knew what they were there for. They weren't just walking into an unknown scene, finding some random man asleep in the vehicle. They got a call. They're working that day. They're doing their due diligence. They got a call and they responded to a scene. Michael Ayler testified to that. There is no requirement, and if there is, I'm gonna learn from defense counsel later, that an officer has to walk up to a vehicle and touch it to ensure it's running when they come to approach a vehicle during a traffic stop or any type of scene they're responding to. So again, defendant's own word. It doesn't make sense. And I hate saying common sense because I know we are all intelligent people and we can put the puzzle pieces together like Kyle talked about. The puzzle pieces together. There's no issue as to the date, July 13th, 2021, even the defendant testified to that himself. There's no issue as to location, Jefferson County, Texas. He admits to being in Jefferson County, Texas. He admits to driving into Jefferson County, Texas. Driving, operating a motor vehicle. Police officer admits Jefferson County, Texas. No issue as to this not being Cody Clinton Williams. He admits that was him. We got those 3 elements, we're good there. Did then and there operate a motor vehicle? That's what defense is claiming did not occur. We have the real witness placing him on the scene. Right, let's go to the next one. In a public place, this one's silly. We know what a public place is, right? We're driving down a roadway, we're on a bridge. You're almost running into vehicles in the other lane of travel. Okay, while intoxicated. We all talked about it. We have 3 different definitions: the loss of mental faculties, the loss of physical faculties, and then blood being greater than 0.08 or more. I can understand having trouble finding the definition for loss of mental or physical faculties. The defendant did not agree to SFSTs. And he wants you to believe that we're just out to get him because he didn't do SFSTs. That's not the issue. We got the blood. The blood does not lie. 0.172 over double the legal limit. And he wants you to believe 1 beer for 7 hours with a car off in the middle of July. In his words, probably 120 degrees. But if your windows are up and your car's off, it probably is 100 degrees in that car. And with an alcohol concentration of low 0.15 or more. Again, 0.172. I know a lot of you are probably, like I said, excited to be done with this trial, but y'all have the honor and the privilege to go back into that jury room and deliberate. And we're here for a good reason. And there's three. Kyle talked about it during board hour. I'm gonna talk about it with you real quick. Public safety, deterrence, accountability. Public safety, we have a will witness came in, still stressed out 4 years later from what he witnessed. These are the same roads you travel to get here today, the same roads I travel to get to work today, the same road I take my daughter to school on every morning. Public safety. Deterrence. If deterrence and accountability kind of go hand in hand. If we don't hold people accountable, are we really deterring future actions? So think about that. And again, I have a motto at this point, the defendant's own words, it doesn't make sense. So I'm gonna go ahead and submit to you that in Jefferson County, Texas, on July 13th, 2021, the defendant, Cody Williams, did in fact operate a motor vehicle while intoxicated with a blood alcohol concentration level of 0.15 or more. And with that, I'm gonna leave you. I know y'all are tired of hearing me talk. I'm gonna ask that you find the defendant guilty of the DWI enhanced with 0.15 greater or more. And I thank you, me and Kyle both, for allowing us to present this case to you, and have a great day.
Okay, ladies and gentlemen, for the jury, you just heard the closing arguments from the defense and the state. At this time, you'll go into the jury room. Now, I think it was mentioned earlier that we have 6 people on a misdemeanor case in the jury. You notice it's 7. And the reason why it's 7, because one person is the alternate, and the alternate is not allowed to go into the jury room. And the alternate in this case is Angelique Cashmere. Is that correct? Ms. Cashmere? Okay, so Ms. Cashmere, you'll be allowed to, you can stay in the courtroom or in the hallway. And so at this time, I'm going to hand the charge to the bailiff. You can follow the bailiff into the jury room. And the court will be in recess until the jury returns with a verdict. Okay, court will be in recess. Okay. Jefferson County Court at Law number 2 is now back in session. Court is in session and calls number M330658, case is styled the state of Texas versus Cody Clinton Williams. Let the record reflect that the attorney for the state, the attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Four-person. Have you reached a verdict in this case? Okay. Is the verdict unanimous? That is one that is agreed upon by all the jurors.
It is, Your Honor.
Okay. Please hand the verdict form to the, please hand the whole thing to the bailiff to be delivered to me for inspection. Four-person. Is the verdict the unanimous verdict of all members of the jury? Okay. Mr. Williams, would you please stand? And the verdict states, we the jury find the defendant guilty of driving while intoxicated and blood showed an alcohol concentration level of 0.15 or more at the time the analysis was taken. Does anyone, any state or the defense would like to have the jury polled?
No, not yet.
Okay, you may be seated. So at this time, ladies and gentlemen of the jury, I'd like to thank you for your time and attention to this case. Know that you've been here 3 days and you paid strict attention to all of the evidence that was presented. On behalf of the citizens of Jefferson County, on behalf of the staff here in County Court at Law number 2, we'd like to thank you for taking time out from your busy schedules to be here these past 3 days. Now, this will end your jury service. What the lawyers may want to talk to you after you leave the courtroom. You can talk to them if you want to. If you do not want to talk to them, you do not have to talk to them. The defendant, Mr. Williams, has elected to have the court or the judge to set the punishment in this case. And it is customary for the court to order what is called a pre-sentence investigation report. Unless the parties come to an agreement regarding the punishment, then we will not have to order a pre-sentence investigation report. Now, as I mentioned to the members of the panel who was here, who was not selected on this jury, I'll mention the same thing to you. Anytime that you're in the area, County Court at Law number 2, you can come and have a seat in your courtroom to see what goes on. If you cannot come into the courtroom, you can watch it on YouTube. Now, if you come into the courtroom, you can sit in that area in the back. We call that the peanut gallery, but it doesn't mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on in Jefferson County. And I assure you that you'll find that it is very interesting. Now, again, ladies and gentlemen, This will conclude your jury service. If you need anything regarding your jury service, we have our district clerk's office that is right across the hall. They can give you what you need. If you need any excuses, I think we can get that from here. So before you leave, I need to remind you that the bailiff have some letters that she can give to each and every one of you. And before each and every one of you leave, I need to give each and every one of you an air handshake. So at this time, giving each one of you an air handshake, thank you for coming. And please do not hesitate to come back to your courtroom. At this time, you are excused, and you can turn in your tag. You could just leave them on the table. Yeah. Okay, thank y'all for coming. Y'all have a blessed day. Very much. Okay, you're welcome.
Oh, across the hall with,
Y'all may be seated. Jefferson County Court at Law number 2 is back in
That's what-
session and cause number M 330-658. Case of style of state of Texas versus Cody Clinton Williams. We have Mr. Williams, who's present in court with his attorney. Mr. Williams, would you please raise your right hand? Mr. Williams, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Williams, you may put your hand down. And Mr. Williams, you're represented in your case by your attorney, Giles Cole. Attorney Cole, I have before me, well, first of all, Mr. Williams was found guilty of driving while intoxicated with a blood alcohol concentration level of 0.15 or more by the jury. The state and the defense has come to an agreement regarding the punishment. Is that correct, Ms. Simmons?
Yes, Your Honor.
And is that correct, Mr. Cole?
That is correct, yeah.
Oh, man, this been having this thing open so long, it's going out on me.
Oh, yeah, you could just log out. You could use this.
I was sending it back to you, so you got to send it back to me to log out. Just send it back to me. Okay. Okay, now, Mr. Williams. I have before me, Mr. Williams, a document that is titled a misdemeanor plea admonishment, is also labeled as State's Exhibit number 1. Mr. Williams, do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty, and it's guilty by jury trial, and a set of initials of CW. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled, okay, we didn't need to do that one then if it was already on here. I'll post certification. This is not a plea bargain case. Erase that.
I believe only the second box.
Yes.
Checked, Your Honor.
Now, I have a document on me that's titled trial court certification of defendant's right of appeal. I erased the box that said this is a plea bargain case because this is not a plea bargain case. There's one box that's checked. The box that's checked states that you're waiving your right to an appeal. Is that correct?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
Now, Mr. Williams, before you signed and initialed these documents, did your attorney go over these documents with you?
I thought it was we was all kind of understanding this is a jury. The jury found me guilty. No.
Okay,
blood
but
alcohol,
listen to
and
my question. My question was, before you signed and initialed these documents that I just showed you, did your attorney go over these documents with you? Did he go over the documents with you before you signed and initialed these documents?
Yes, Your Honor. Yes.
Okay.
Sorry.
Now, did you understand everything that your attorney went over in these documents? When he went over these documents with you, did you understand what he went over?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. Now, Mr. Williams, are you a citizen of the United States?
Yes, Your Honor.
State would offer state one at this time, Your Honor.
No objection. State's exhibit number 1 will be admitted. Now, Mr. Cole, you advising counsel, Mr. Williams, is there any evidence that he's currently mentally incompetent to stand trial?
No.
Mr. Williams, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Okay. Now, Mr. Williams, has Mr. Cole provided full, effective, and competent legal representation?
Yes, Your Honor.
Okay. Now, Mr. Williams, the court will find that you are competent to stand trial. The court will accept your plea and waivers. And the court will also find that there is sufficient evidence to find you guilty. And the jury has found you guilty beyond a reasonable doubt. State, do we have an agreement regarding the punishment in this case?
Yes, Your Honor, we do.
And what is that agreement?
Following a verdict of guilty, the state and defense have agreed to 93 days in the Jefferson County Jail, to which the defendant has credit for 93 days in the Jefferson County Jail, and all court costs are be taxed and retired.
Okay. Now, Mr. Williams, the state is offering you to serve 93 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case, because you've already served 93 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. And the court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs, because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Williams, do you understand the state's offer?
Yes, Your Honor.
And do you think that the state's offer in this case is fair and just?
Yes, Your Honor, I do.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Williams, I'll follow the agreement that you made in this case regarding the punishment. And Mr. Williams, this will conclude your case. You will stand next to the bailiff, follow her directions. And then once you finish following her directions, you can follow the bailiff.
Thank you.
Might be excused, Your Honor.
Yes, you may be excused.
Good job today, counsel.
Right over here, in a minute, right? Wait until we do it.
Okay, Mr. Good.
Yeah.
Yes, the state, you may be excused. And this will conclude the calling of the court's jury trial in cause number M330658, State of Texas versus Cody Clinton Williams. Everyone, please have a blessed day.